There may be great news for you if you have a case in U.S. immigration court. Now, I've shared several videos explaining what the latest news is. If you have a removal case or deportation case pending, you want to listen in. So in about 2021, the latest memo was released by Mayorkas, and it's actually, that's the Secretary of Homeland Security. He released this memo to show the guidelines according to which the Department of Homeland will be prosecuting immigrants. You see, so even if you were a non-citizen and you had to be removed from the US, you were not necessarily going to be pursued. They were going to focus on 3 priority areas, high priority areas to remove non-citizens. And the 3 high priority areas are people who are a threat to national security, such as terrorists, people who are a threat to public safety, who have criminal background or records, and 3 people who are a threat to the border security of the US who came in illegally after November 2020. Because the department has very limited resources, they wanted to pursue these high target priority cases in a process known as prosecutorial discretion. And so if your case did not fall within these high target areas, then you were a low priority case and your case could potentially be dismissed from court. Following this memo that was released to prioritize the high cases, Texas and Louisiana sued the Department of Homeland Security and said, no, we don't agree. We think that you should arrest more non-citizens and process them in U.S. immigration courts. Now, the case traveled all the way up to the Supreme Court, and just last week or a few days ago, the Supreme Court ruled in the favor of DHS and against the states of Texas and Louisiana. The Supreme Court stated that, yes, there are limited resources. The DHS doesn't have so much money and resources to remove every non-citizen who has to be deported from the U.S. Now, there are currently over 2 million cases pending in U.S. immigration courts. So they have to focus on high priority cases. In this video, we're going to be taking a look at how they will do this. How will the DHS prioritize these cases, or how will they exercise prosecutorial discretion? The memo may be reinstituted towards the end of July. The memo that will show DHS, or that will issue the guidelines on how they're going to proceed. What the DHS is going to be doing is, number one, they'll look at which people will even get NTAs. NTAs are what will actually summon you into immigration court. So not everybody who breaches the law or has to be removed will get an NTA or be even summoned to immigration court. They will decide not to even pursue certain appeals. If you win, they'll just leave you. They won't pursue appeals. They will decide to terminate or close your case from immigration courts and allow you to get a green card outside of immigration courts, and a few of other ways. All of these actions will be in a bid to exercise prosecutorial discretion in non-priority cases, so that they will use their limited resources to focus on cases that were considered as high priority. Okay, so guys, that's the latest news. This is how they are going to be exercising prosecutorial discretion for cases in immigration courts. And please note that very strong preference will be given by DHS to efficiently remove non-priority cases altogether. That's the best way. They will just remove it altogether to best focus the resources on the priority cases, as we have discussed. I hope this helps. All the best, and follow me for more.